1966 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်32 Master William Jazz and Company Limited Plaintiff vs Yangon Palladium and 5 others defendants ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစောမင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Civil Regular Suit before ဦးသက်ဖေ Judge Master William Jazz and Company Limited Plaintiff vs Yangon Palladium and 5 others defendants Civil Procedure Code Order 6 Rule 17 Amendment of Plain under permission for whether permissible held the plaintiff suit by its original plain was won against the Yangon Palladium Fund and its partners, whereas the suit under the proposed amended plain would be won against the late Domama, represented by her as an legal representative. The original plain did not contain any allegation that the claim of the plaintiff was due by either Domama or her estate. Moreover, Domama was never a partner of the Yangon Palladium firm, and therefore she cannot be brought on the record through her as an legal representative without changing the nature of the suit. Mukhi Jiramdas Jetanan and others versus Tikamil Muchand and another AIR 1935 Cindy 194 Fem Ahmed Musa Brothers vs Fem Lilaram Takamdas AIR 1942 Cindy 93 Serinasat vs Nanle and others AIR 1948 Out 44 K. Vangataswa Yanara Yana vs Akututa Rameya and another AIR 1921 Madrid 98 refer to Mr. C.A. Soma for the plaintiff, Umau Mao and Ula Singh for the defendants. Uttapi Judge, this is an application for amendment of plain under Rule 17, Order 6 of the Civil Procedure Code. The brief facts which have given rise to the present application are these. On the 24th of December 1963, the plaintiff, Master William Jazz and Company Limited, sued the firm known as Yangon Palladium and 5 of its partners, Domya Teng, Donyon Wei, Umya Han, Dotan Nu and Usan Luen, for recovery of debt 63,575, 72 bia due for work done in respect of the Palladium Cinema. Then on 28 February 1964, the plaintiff obtained leave to bring on the record the name of another partner, Domama Ji, who was thought to be dead but was in fact alive at the time of the institution of the suit as a party defendant. The parties thereafter proceeded with the trial of the suit, during the progress of which the plaintiff came to realize that their claim could only be recovered from the late Domama, the owner of the Palladium cinema, and not from the Yangon Palladium firm and its partners. It appeared that the late Domama was survived by 8 children, namely the 6 original defendants, who were the partners of the Yangon Palladium firm, and Daw Min and Wu Shuibo. The plaintiff thereupon sought to amend the court's title of the plaint by striking out the name of the Yangon Palladium and adding the names of Daw Min and Wu Shuibo respectively to and from the array of defendants. The plaintiff further proposed to sue the defendants as an legal representative of the late Domama. This move of the plaintiff was, of course, stoutly resisted by Daw Min and Wu Shuibo on the ground that the amendment would alter the nature of the suit and that it would take away from them a legal right which had accrued by lapse of time. The other defendants, on the other hand, filed a joint petition agreeing to a decree for Jet 55,818 being passed against them as an legal representative of the late Domama. Now, it is clear that the plaintiff suit by its original plaint was won against the Yangon Palladium firm and its partners, whereas the suit under the proposed amended plaint would be won against the late Domama, represented by her as an legal representative. There can be no room for doubt that the nature of the suit would be altered if the proposed amendment were to be allowed. The original plaint did not contain any allegation that the claim of the plaintiff was due by either Domama or her estate. No doubt, 6 of the 8 as an legal representative of Domama are partners of the Yangon Palladium firm, but that does not enable the plaintiff to sue their mother, Domama, who had nothing to do with the partnership. No doubt, 6 of the 8 as an legal representative of Domama are partners of the Yangon Palladium firm, but that does not enable the plaintiff to sue their mother, Domama, who had nothing to do with the partnership. In Mukhi, Jeremdas, Chetanan, and others versus Tikamil, Muchen, and another one, it was held that, under Order 1, Rule 10, a person may be added as a party to a suit in the following cases. 1. When he ought to have been joined as plaintiff or defendant and not so joined. Or 2. When, without his presence, the question in suit cannot be completely decided, whereby allowing a person to be impleaded as a party, the nature of the suit will be altered. The application should not be allowed. In Fem Ahmed Mosa Brothers versus Fem Lilaram T. Kamdas 2, the amendment to change the suit against the Fem to one against an individual who happened to be a partner of the Fem was rejected as it would alter the nature of the suit. In the present case, the late Domama was never a partner of the Yangon Palladium firm, and I fail to see how she can be brought on the record through her as an legal representative without changing the nature of the suit. In Sherry Net Sef vs. Nanley and others 3, it has also been held that a party should not be added so as to change the nature of the suit, but when no new question will be raised by the addition of a person as a party, and on the other hand, the addition of the person is necessary to avoid a multiplicity of proceedings and to protect the rights of the defendant, he should be implemented. See also K. Vangadaswa Yanarayana vs. Akutota Rameya and another 4. In the result, the application for amendment of plain fails and is dismissed with cost, advocate fees, Jet 34,